All right, let's go to Karen calling.
Hi. Thanks for taking my call. I was just wondering, what do you charge? My husband and our children are grown, and we do not have a will. He has kids, I have kids, and we need a will. What do you charge to, say, come in and
all right,
set
well,
that
you
up?
can check out all of my fees on the website, but I'll tell you. But the website is just attypip.com. So we charge like $150 each for a will.
Okay.
Most clients who do wills do durable power of attorney / healthcare surrogates. They're documents so you would avoid being declared incompetent, basically, and someone to make healthcare decisions.
Yes.
Most clients do a living will that says if you're terminal, vegetative, unconscious, end stage, you don't want to be artificially prolonged. You will be given information to have a choice between a will or a trust. Now, the questions I ask on whether in preparing those documents are the same, basically. It's the difference at the end of the day when you pass on, because your will would probably go through probate and your trust would not.
Okay.
So a living trust is just a fancy will. You create it while you're living. You're the grantor. You're the trustee. When you die, the trust is living, so the assets are not in the name of a deceased person. Your children, if you have children, could be the successor trustees, and they could pay your bills and finalize the taxes and distribute everything in the estate out according to your wishes with no probate very quickly and privately. You need to know with wills, it's going to be a public record. There's a long, drawn-out process. It's a public record. The statutory recommended fees are 3 to 6%. Takes a year. With a trust, it can be quick, no probate, private. And the difference between what I just quoted on fees and trust is not that difference. If you added up those, $150 for a will times 2, $150 for a durable power of attorney healthcare surrogate times 2, and living wills is like $750, and you get a trust package for $895, which includes all of those documents plus the trust and the deed of your house putting that into the trust. Have you heard of a trust before?
No, I guess I really didn't think that. I didn't know there was a difference really between a trust and a will.
Yeah, well, the difference is you die with a will, you die with assets just in your name. You die with a living trust, the assets are not in the name of a deceased person, they're in a living trust, and the successor trustee can distribute them out without any court proceedings.
And is it true that, so if you're married and your spouse dies, does everything go to the spouse, or everything has to be written down?
Well, let me ask you this. Now, most husbands and wives own everything jointly.
Well, we don't, though. He has a truck that's in his name.
Does he have a will that leaves everything to you?
No.
Well, vehicle's a little bit different. I think the spouse would get the vehicle in that. Is it a first marriage? Because there are lots of little questions.
No, that's it. It's a second marriage, and he has 2 children. I have 2 children. They're all grown children. With children, we have 7 grandchildren. So we have lots of people. Yeah.
Do y'all want everything to go to each other?
Yes.
Okay. So you need wills to do that. Otherwise, the children would come into play for part of the estate by statute. Ah. So if you want each other to have everything, you definitely need wills that leave everything to one another. Other than that, you could be arguing with the children about certain things. Not that there's an argument, because there's a statute that controls it.
Sure. Interesting. Yeah, that's good to know. Okay.
All right. And you're calling from where?
St. Petersburg.
Okay. All right. Well, very good.
Okay,
if you have more questions, call me anytime. Thanks. Okay, you're listening to Ask an Attorney all about Florida law. If you'd like the free estate planning poster sheet, you can contact my office. If you want, you can do that one of 3 ways. You can call our toll-free office number again, which is 1-800-226-3529. That's for either an appointment or to request the free estate planning poster sheet, which clearly outlines all the differences between wills and trusts and some of the benefits and disadvantages of the three options in estate planning. You can also text me at or fax me at 727-585-4209. You can email me at joe, at attypip.com. You can text me at 727-667-3967. And again, host of Ask an Attorney all about Florida law, which is every Saturday morning on 570, 910, 860, 930, and all the stations, and plus there are a bunch of other stations around Florida that carry the program. And it's a live show where people call in and ask legal questions, just like several of you did today. And I'll be more than glad to answer your questions and get you pointed in the right direction. Also, you can follow us on Facebook. We have Ask an Attorney page and a Law Offices of Joseph Pippen page. We're also broadcast every other week on WeBeam TV. I appreciate you listening and calling in with your questions, and hope you join us soon for another edition of Ask an Attorney, all about Florida law. You be safe. Thanks.